दिव्य सज्जनों, आज के इस प्लेटिनम जुबली समापन समारोह में मंच पर हम सबके बीच गरिमामयी उपस्थिति है सर्वोच्च न्यायालय के माननीय न्यायाधीश और नालसा के एग्जीक्यूटिव चेयरमैन ऑनरेबल मिस्टर जस्टिस संजीव खन्ना जी की। मैं उनसे निवेदन करूंगा ऑनरेबल मिस्टर जस्टिस संजीव खन्ना से कि वे इस अवसर पर अपने संबोधन के लिए पधारें।
Respected Shri Narendra Modi ji, the Prime Minister of India, Shri Haribhau Kisan Rao Bagde ji, the Governor of the State of Rajasthan, Shri Bajralal Sharma ji, Chief Minister of Rajasthan, Shri Arjun Ram Meghwal ji, Minister of State, Law and Justice, Shri M.M. Justice Srivastava, Chief Justice of Rajasthan High Court, brother judges from the Supreme Court of India, sister and brother judges from High Courts, retired judges, judicial officers, advocates and distinguished guests, Namaste and good evening. 75 years ago, on 29th of August 1949, the High Court of Rajasthan was established. Just a few months before adoption of our Constitution, on 26th November 1949. As we reflect on the journey from time of our freedom fighters to the constitutional visionaries of the present day, we must acknowledge that we are today, as a nation, 3 or 4 generations old. The demand of our forefathers, laying the foundation of our nation and drafting the Constitution, started from the baseline. Democracy as a system of governance places power in the hands of the people. The governments we elect and the laws they enact derive their legitimacy from the choices made by the electorate. To effectuate our common constitutional goals, the forefounders enshrined justiciable fundamental rights like the right to equality, the right to life, the freedoms to speech and thought and association, among others. These rights are the spirit of our Constitution. We Indians respect and take pride in our Constitution. Today, India is a home to the largest young population in the world. More than 65% of our population is below 35 years. Ironically, most of us present here do not belong to this age. Do we understand their aspirations? In my opinion, these young citizens, the torchbearers of our future, seek more than just basic norms and rights. They yearn for good governance. What is the difference between governance and good governance? Governance refers to the processes of governing the institution and practices through which the issues of common concern are decided upon and regulated. Good governance adds a normative and evaluative attribute to the process of governing. As per United Nations Economics and Social Commission for Asia and Pacific, good governance has 8 major characteristics. These are participatory, consensus orientation, accountable, transparency, responsive, effective and efficient, equitable and inclusive, and follow the rules of law. To this, I'll add one more: ability to take hard and right decisions. Consequently, the key difference between governance and good governance lies in the quality of outcome of governance. Good governance minimizes and eradicates corruption. All branches of government, including judiciary, share this common mission to provide good governance. This objective is achieved by enacting good and compliable laws, their effective and fair execution, and an independent and impartial judiciary which interprets the law as the will of the people and adjudicates disputes fulfilling the constitutional role and objective. Should the judiciary be tested on the parameters and scales of good governance? My answer to that is yes, and it requires further effort on our part because judiciary is required to be just, fair and equitable. Their decisions, though examining various perspectives, should not discard harmonious coherence and certainty. We have to maintain a right balance between consistency and change. The judges must mitigate against the impact of personal biases and insulate their decisions from any undue sway of collective and external pressures. The judicial process should be easily accessible to common persons. It should be inexpensive and not burdensome. Courts should be citizen-friendly and litigant-driven. Decisions must be rendered without any delay, and the judgments should be simple so that they are understood by the litigants and general public. As an executive chairperson of the National Legal Services Authority, NALSA, I'd like to take this opportunity to show cause and share with you another aspect of judicial attempt to provide good governance. The vision of NALSA is an inclusive legal system providing free, fair and competent legal representation in the courts of law. Besides this, there are four other equally important objects and goals for an inclusive vision of NALSA. These are disseminating legal literacy and awareness, providing assistance to bridge the gap between socio-economic welfare schemes and actual realization of benefits of such schemes, enacting and implementing strategic schemes for the vulnerable in our society, providing quick, cheap, effective resolution of disputes through alternate dispute resolution mechanisms. Today, NALSA provides largest coverage of legal aid in the world, as nearly 80% of our 1.4 billion citizens are eligible for free legal aid. The number of legal aid beneficiaries have quadrupled in 7 years, going from 3 lakhs in 2015-16 to 12 lakhs in 2022-23. Today, the figure should be touching about 17 lakhs. NALSA has enrolled about 49,000 advocates on its panel. The legal aid force is also bolstered by 42,446 paralegal volunteers, out of which 17,506 are women, comprising of 41% of paralegal volunteers. We have set up 11,800 legal services clinics, out of which 1,196 clinics have been set up in the jails. About 400 clinics have been set up in juvenile justice centers. NALSA has also developed strategic schemes like victim compensation scheme targeted towards empowering some of the vulnerable sections of our society. In 2023, a substantial sum of 308 crores has been paid under different compensation schemes. We have promoted alternate dispute resolution mechanisms like Lok Adalat and mediation for fast, quick and mutually acceptable resolution of disputes in place of adversarial adjudication. In the past 6 years, more than 17 crores cases have been disposed of by Lok Adalats. Between 2016 to 2022, pan-India, 11 lakh cases have been settled through mediation. I am also happy to state that state of Rajasthan has pioneered the concept of open jails for prisoners, representing a bold and forward-thinking approach towards prison reforms. These open prisons are helping individuals in conflict with the law to rediscover their place in the society. Out of around 6,000 convict prisoners, Rajasthan proudly hosts 1,400 prisoners in conflict with law in 23 such camps or open-air jails. Rajasthan also has the highest number of pro bono lawyers in the country. 1,198 lawyers have enlisted themselves to provide pro bono services to those in need. Let us work towards a society where governance and fundamental rights are not seen as opposing forces, but as partners in pursuit of progressive, strong, as well as just, equitable, and harmonious India. This is a vision we must all commit to, where governance truly serves the people, where the well-being of others and the society and every individuals are protected and cherished. Thank you and Jai Hind.
बहुत बहुत आभार ऑनरेबल मिस्टर जस्टिस संजीव खन्ना जी, ऑनरेबल जज सुप्रीम कोर्ट ऑफ इंडिया का, उनके संबोधन के लिए।